This presentation provides an update on the Nevada Department of Agriculture's state plan and the requirements listed under the Agriculture Improvement Act of 2018. The Agriculture Improvement Act of 2018 requires states that intend to have regulatory oversight over hemp production to submit a state plan that details how they will meet federal requirements. To provide an update on the federal requirements that must be listed in the state plan, in addition to the Nevada Department of Agriculture's current regulatory authority and approach for meeting federal compliance, this presentation is being provided. Ideally, we would have this presentation in person. However, due to the current health crisis, this presentation has been prepared to ensure that folks are informed. If you have questions or comments, please feel free to email the contact at the end of this presentation. Thank you for your support for the Nevada hemp industry. In order to continue to support the Nevada hemp industry, the Nevada Department of Agriculture will be submitting a state plan to USDA in order to ensure that we have federal approval to move forward with a program. This state plan must meet the minimum requirements as listed in the Agriculture Improvement Act of 2018, in addition to the details that are listed in the interim final rules. The interim final rules are still under review by USDA as they are taking public comment. Any changes that do take place within the interim final rules will have to be reflected in the state plans, and a revised state plan will have to be submitted. The Nevada Department of Agriculture will continue to work with USDA in order to ensure that we have federal approval. This slide provides some history involving Nevada's state hemp program. The 2014 Farm Bill legalized the research and development of hemp under State Department of Agriculture supervision. In order for Nevada to participate in this opportunity, Senate Bill 305 was approved. By June of 2017, the first growing season was underway, and to allow for limited processing of raw hemp, Senate Bill 396 was passed. In December of 2018, the 2018 Farm Bill was passed that fully legalized the production of hemp for states that have a USDA-approved hemp program. This also established a national regulatory framework for hemp production. In order to reflect these new requirements, Senate Bill 347 was passed to demonstrate alignment with these new requirements. In addition, Senate Bill 209 was signed into law that required the opportunity for the retesting of crops that may have failed their initial testing. In October of 2019, USDA published the interim final rules, which govern the production of hemp under the 2018 Farm Bill and require state plans to be submitted to USDA. State plans must be approved by USDA by October 31st, as this is when the pilot program that was launched in 2014 expires. This slide further details what was aforementioned in the previous slide involving Nevada's history in response to federal requirements. The definition of hemp is particularly critical to understanding the intent behind these federal regulations. The term hemp means the plant Cannabis sativa L and any part of that plant, including the seeds thereof, and all derivatives, extracts, cannabinoids, isomers, acids, salts, and salts of isomers, whether growing or not, with a delta-9 tetrahydrocannabinol concentration of not more than 0.3% on a dry weight basis. Now, these restrictions are put in place to ensure that this crop does not end up having psychoactive properties, which is why derivatives, extracts, and so forth have also been included. As a result, chemical analysis must take place to ensure that this is hemp, as it is also a cannabis plant, as you can see from this definition. The interim final rules were published at the end of October 2019. This allowed for a 90-day comment period, which was extended out to January 31st of 2020. The Nevada Department of Agriculture notified their previous certificate holders that this comment period was open, and this was also released to the public via a press release. The interim final rule defines areas that states must encompass in their state plan. Now, this includes tribes as well that intend on having a plan for their tribal land. Comment that was provided during the comment period is still being assessed by USDA for integration into the final rules. However, anything that was specified in the 2018 Farm Bill in terms of requirements will remain and would need to be changed through federal legislation. This slide details the state plan requirements that were outlined in the 2018 Farm Bill and further specified in the interim final rules. Much of this the Department of Agriculture already had in place. However, our compliance must be demonstrated to the United States Department of Agriculture to proceed with a program. This includes a plan to maintain relevant producer and land information, a plan for sample testing using a post-decarboxylation or similarly reliable method, a plan for disposal procedures, a plan for inspection procedures, a plan for collection of information, and a plan to comply with enforcement procedures. In addition, adequate personnel must be in place to implement the requirements of the Farm Bill and the interim final rule. We will further describe Nevada's current regulatory authority that would allow them to continue with the program throughout this presentation that also will be submitted to USDA. One of the first requirements of the state plan is to ensure that states have a means of maintaining relevant production information. The Department of Agriculture has been doing this since they initiated their program and has a means of accepting registration information and tracking those details. The regulations and statutes that allow for this are listed in this slide. All Nevada hemp production must be certified by the NDA, which emphasizes hemp grower certificates, hemp seed producer certificates, and hemp handler certificates. Now, the requirements of the state plan are specific to the grower certificate, and the other two are additional services the department provides. The department will be providing their current application as demonstration that we have a mechanism of accepting this information in addition to these regulations and statutes. USDA requires that state plans detail how the department will receive registration information. The Nevada Department of Agriculture has authority under Nevada Revised Statute to receive application information in addition to regulations under Nevada Administrative Code 557. Applications received are reviewed on an annual basis. They are issued based on the date that certification is approved, and they expire on December 31st of that year. Applications must detail landowner approval, in addition to approval from local jurisdictional authorities. They must include information on the location, the acreage and square footage, potential varietals, and intended production details. Further information is provided within this application on compliance testing in addition to the crop disposal requirements if the crop is non-compliant per federal requirements. The Agriculture Improvement Act of 2018, and is further described in the interim final rules, requires that criminal history be provided with applications. The criminal history report must include key participants of the application, and they must not have been convicted of a state or federal felony related to a controlled substance for the 10 years prior to the date of when the report was completed. An exception applies to a person who was lawfully growing hemp under the 2014 Farm Bill before December 20th of 2018 and whose conviction also occurred before that date. Now, currently under Nevada Administrative Code 557, a background check is only required back 5 years. To demonstrate compliance with this requirement, the department is requesting that a background check of the past 10 years be provided in order to demonstrate that we're trying to meet these compliance requirements until a regulation change can be sought. Key participants will also need to be included in the definitions within Nevada Administrative Code. These are defined in the interim final rules as a person or persons who have a direct or indirect financial interest in the entity producing hemp, such as an owner or partner in a partnership. A key participant also includes persons in a corporate entity at executive levels, including Chief Executive Officer, Chief Operating Officer, and Chief Financial Officer. In the state plan, again, we will detail that we will be requesting the background check for the past 10 years in order to demonstrate compliance until regulations are able to be amended. The Agriculture Improvement Act of 2018, and is further defined in the interim final rule, requires that hemp compliancy testing be performed using a post-decarboxylated delta-9 THC or a similarly reliable method. This must include the conversion of THCA to THC, as this would reflect potential psychoactive properties that could be in the sample. As was previously mentioned in this presentation, hemp is also a cannabis plant, and as a result, a numerical value has been assigned to the definition of hemp to demonstrate that it is psychoactively different than marijuana. A naturally occurring delta-9 testing method does not reflect the conversion of THCA to THC, as a sample that could have potential psychoactive properties could pass this testing method. The Nevada Department of Agriculture has authority under Nevada Revised Statute 557 and regulations under Nevada Administrative Code 557 to perform sampling for delta-9 THC. And again, this method must reflect the conversion of THCA to THC. The department utilizes a high-performance liquid chromatography testing method to determine total potential THC that would be present in the sample. This is considered an appropriate method per the interim final rules, as it reflects a similarly reliable method to post-decarboxylated delta-9 THC. The Agriculture Improvement Act of 2018 and interim final rules require that state plans detail how they will verify that disposal plans are submitted and executed for non-compliant crops, meaning they exceed the legal THC limits assigned by federal law. The department has authority under NRS 557 to require crop disposal for those non-compliant crops, and this was amended to reflect federal regulations in Senate Bill 347, Section 12. The Department of Agriculture requires growers to submit a crop disposal plan for review. This must take place prior to disposal. Since production circumstances may vary, the plan will be reviewed to ensure that it meets the needs of the USDA requirements and also the needs of the grower. Disposals must be overseen by law enforcement per the federal regulations. State plan requirements include that departments of agriculture detail how they will be taking enforcement and that they have adequate authority for taking corresponding enforcement against any violations to the hemp program. This could include unregistered hemp production, failure to dispose of a non-compliant crop, working outside of their registration information, and so forth. The NDA currently has regulatory authority under NRS 557 to perform enforcement, and regulations detail said enforcement under NAC 557. Enforcement activities can include loss of certification, denial of future certification, and/or a fine. This will be demonstrated in the state plan to verify that the state has current regulatory authority to pursue enforcement. In order to perform the chemical analysis that must take place to confirm that the crop is hemp, sampling must occur. The Department of Agriculture has authority to perform sampling under NRS 557. In addition, regulations for sampling are defined under NAC 557 as well. Currently, the department is collecting samples of equal parts flower to stem and leaf. Now, we do not know if this will be accepted by USDA, as the interim final rules suggest only flower. However, since only flower was not specified in the 2018 Farm Bill, this will be submitted to the USDA to determine whether it will be accepted. If they do not accept it, we will go with whatever their recommendation is for sampling that would allow for the state plan to proceed. In the state plan, there's a requirement to ensure that there is information sharing with law enforcement and the Secretary of Agriculture regarding all registered applicants. This must be maintained for 3 years and there must be regular reporting. As a result, NDA will include in the state plan how they will be going about information sharing, and there's already a designated link as to how this information will be shared. Current regulations under NAC 557 do specify that information can be shared with law enforcement, as this is critical for them to identify whether it's a registered and legal crop. Per the interim final rule requirements, and as specified in the 2018 Farm Bill, state departments of agriculture must demonstrate that they have adequate hemp program personnel in order to execute the requirements of these programs. The NDA has established new positions and leveraged existing positions' seasonality in order to fulfill the needs within this program. Below highlights some of the programs that are currently being used and that have been requested to provide additional support for this program. This is being outlined in the state plan. The department currently charges an application fee in addition to an acreage or square footage fee, along with inspection fees and chemical analysis fees to cover the cost of the program. Additional USDA requirements include that labs performing hemp analysis are DEA certified. The Nevada Department of Agriculture's lab is certified per DEA. This is to ensure that the proper certification is received, as the outcome of the results could demonstrate that it is a controlled substance. Further, per requirements of USDA, a measurement of uncertainty must be detailed for the lab within the Department of Agriculture. The Nevada Department of Agriculture is using a 10% measurement of uncertainty, meaning that crops up to 0.34 would be considered compliant. This is what will be submitted in the state plan for consideration. Further, crop disposal must be handled by law enforcement since it is a controlled substance. This slide highlights potential USDA expectations. These are detailed in the interim final rule. However, they've been specifically highlighted by USDA as being closely evaluated and with potential for reconsideration due to the concerns that have been expressed by other states. These are listed in the interim final rules but are not listed in the 2018 Farm Bill, therefore may be subject to change. One of these specific items of concern is growers are expected to harvest within 15 days of sampling. And we understand this concern as the chemical analysis of that crop can quickly change as the crop matures. However, the 15-day window could provide limitations in being able to resample a potentially non-compliant crop. The Department of Agriculture is required to offer resampling per Senate Bill 209. This would not provide adequate time in order to do so. The department is recommending that crops must be harvested within 15 days after a certificate of analysis is received. We do not know if this will be accepted, and it may be the requirement that crops be harvested within 15 days of sampling, which would require a regulation adoption. Further, an additional criteria that they have listed in the interim final rule is a negligent violation. Now they have this set at 0.5% or greater THC, meaning that any crops that test greater than 0.5% THC, and if this occurs 3 times within a 5-year period, would render the grower no longer eligible for production within 5 years of the third negligent violation. The Department of Agriculture has expressed concern over this limitation, as if a grower has a crop that tests over 0.5%, it doesn't mean that they were performing negligent behavior. There's still much research being performed within this crop. USDA has expressed that some of the criteria that they used in inputting this provision within the interim final rules was testing data that was submitted from departments of agriculture, in addition to questions as to whether the applicant had used certified seed and whether reasonable precautions were taken. Again, USDA has expressed that they are evaluating this provision closely and it may be subject to change. Thank you for taking the time to review this presentation. Of course, we would have preferred to have had this presentation in person, but due to the current circumstances, we wanted to be sure that you had access to what the requirements are that must be included in the state plans, what the Nevada Department of Agriculture's current authority and regulations are that align with these requirements, in addition to our approach for ensuring that we meet federal requirements moving forward. Mind you, there may be changes to the state plan depending on feedback we receive from USDA or any changes that may occur to the interim final rules. We will be working hand in hand with USDA to make sure that we're able to have a compliant program that meets their requirements in order to support this industry. Should you have any questions or comments, please feel free to send to the email provided in the screen. Thank you.